two periods. And therefore, I invite you to reserve your questions, and I will be so happy to answer them at the end of each part. It is my pleasure also to tell you that, yes, I'm a practicing lawyer. I've been practicing for the past 30 years, and what I do as a practice is litigation. So, therefore, I am not a notary, but I am pretty much knowledgeable of these tools, and I will tell you out throughout the presentation. I am also pretty familiar with English, so but it's not my first language, so if I do step on a word, please be generous of your comprehension, because it's not my first language. In any case, let me talk to you about these institutions, these legal documents. And as an introduction, I would like to recall to you that what we are looking into at this moment are legal documents that have different meanings and have differences. And all of them are useful, and all of them may coexist. We will see throughout the presentation what are the differences between the different legal documents, how useful they can be, whether they coexist at all times, and yet maybe also as a preliminary element, we need to say that none of them is obligatory. You are not imposed on signing such a legal document. What you're imposed in life is really to make your tax declarations. This is imposed. But these documents, we will retain at this moment that they can be useful. They can be useful for you, and they can be useful for those who are surrounding you, your family members, your companions, your friends, etc. In our society, Canadian Quebec society, we have these important premises. And as a perspective, we can agree on the fact that in our system of law, the person is the primary concern. We give a lot of importance on a person's express wishes. It is, in fact, in our Quebec law, primary in terms of preponderance, in terms of importance. Therefore, we have set up the possibilities to decide in advance, make decisions that we call anticipated. Anticipated to death, if we're talking about wills, and anticipated to incapacity, if we're talking about mandate in case of incapacity or protection mandate. So these express wishes and anticipated decisions may be set in legal documents that will be written, that will be signed, and that will be registered. And this is where they find their usefulness, because they will be, then they will be, they can be at some times opposed to other people. The foundation in our system, whether Canadian or Quebec, is really based on the importance we bring to two major notions: dignity and autonomy. By dignity, we mean this fundamental value enshrined in our Quebec Charter, with this principle that dignity underlies the rights and freedoms guaranteed by the Charter, whether it's right to life, right to privacy. Dignity is a fundamental value, which is a principle that is not only in the Charter, but is also reiterated in different court decisions, Supreme Court, Quebec Court of Appeal. And this is of major importance once we consider that any and all these documents need to be respected because they are attached to the expression of a human being who is entitled to respect of its dignity. Autonomy of the person does refer to the principle fully accepted in our province, which is the fact that a person is presumed capable. Person is presumed capable. This means that we don't need to make a demonstration that we are capable. It's for those who contest our capacity to prove that we are incapable. The incapacity is an exception, and therefore we need to remember that it's for those who criticize or question our capacity to demonstrate that one is incapable. So this being said, it means that if we are presumed to be capable, then we are presumed to make valid legal documents, sign legal documents without questioning the fact that we may be less physically able, but we are still mentally capable to express wishes and make decisions, and express wishes in documents in case of incapacity. We will see the notion of incapacity furthermore when we look into closer the case of the mandate in case of incapacity. And by mandate in case of incapacity, I mean the protection mandate. So we will see one after the other these legal documents. The first one being the will, the second one being the power of attorney, and the third one being the protection mandate. Does everyone hears me well? Yes? Good. Now, the will, I don't need to make a drawing for you. I suppose you all know what it refers to, but as lawyers, we always like to be on the same tone and the same level for everyone. So a definition is always of interest. So it's a document signed by a person who is capable installing in advance his wishes regarding the disposition of his body and the distribution of his assets. This is a summary of what we can think of a will. So again, we see that we need to be capable to put in advance our directives upon our death. Minors are entitled to decide in advance the disposition of their body pending approval of their parent. With regards to the power of attorney, this is a contract. So you see right away, you see the difference. So one may contract as a mandatory to nominate another person and empower this person with specific powers. And we will see in closer which type of powers one may, and in what circumstances does a power of attorney is thus put into place and exercised and executed. Third document, protection mandate. As I said, we used to call it for 25 years, the mandate given in case of incapacity. The name was changed about 3 years ago in the law. So it's a mandate. So it's a contract. It's a contract given by a person of full age, which means 18 and over, in anticipation of incapacity to take care of himself or administer his property. It could be for one or for two. It could be for the administration of property. It could be for caring for the person. So there are multiple possibilities. Then again, as with the power of attorney, there are multiple possibilities and situations. We will look into this closer when we come to the protection mandate issue. So let's go into the will issue. So what we said was that will is a document. We will first see what subject it refers to, then we will see the forms. So a will, as I said, is the subject of, or the author of a will is generally a person of 18 years and over. As I said, minors are entitled with regards to disposition of their bodies. So they may decide, assisted by their parent, how they would dispose of how their body would be disposed, rather. So what is expected in a will is that we read the wishes of a person after death. So the document itself is meant to enable a person to decide in advance and to be respected into his or her wishes after his death. In other words, it's like directives being given so that those who will be opening up the will have to abide by the wishes expressed in the person's will. What do we usually read? What does it contain? Disposition of a deceased body and distribution of deceased property. So it does imply multiple juridical acts. It may imply that if I die in another province, my body is going to be repatriated back to Quebec. If I die in another country, my body will be transported back. The same would apply if I die here and I want to be transported back to my original country. Distribution of property may be made as many situations you can think of may be implied into one's will. The will itself will, of course, should demonstrate, show the wishes of the person. One should not be restricted to simple forms or formulas that are already made. One should be able and be in a position to adapt to its own situation, its own life, its own private situation. The condition of execution of a will is obviously death. And when I say that, I mean, because we will be able to compare to the other legal documents, but the condition of execution, meaning that a will shall not be reviewed and decided upon before death. It should not be for the heirs or legatees to decide before death what is going to be done to, for example, the deceased property prior to his or her death. So the will is a legal document. It's recognized. Conservation of a will may be made by the person itself, himself or herself, the notary, the lawyer, an executor. By executor, I mean the liquidator. They're synonymous in our system of law at the moment. We changed the term executor to liquidator, but we all understand it's the same person. And a will may also be conserved, depending on our choice, with legatees or with heirs, it may be. But the conservation itself shall be in a safe place. That's what we shall retain. Now, modification and revocation of a will is always possible. As long as I'm capable, I may change my will. I may modify. I may decide that my car is not going to be given to my son, but rather to my nephew. I may always decide that I revoke my last will because I think right at this moment I would like to be able to give some compensation or retribution or some sort of recognition to a companion. As long as I'm capable, I'm entitled to revoke my will, to modify my will. We will see when we get to the forms that there are some ways to modify. Now, my will may be registered with the Chambre des Notaires or the Barreau du Québec, which is a safe place, which is a place where there are registries set up registries that may be questioned upon, and registries that are safe, not for keeping the will, but for keeping where is a will under the name of a person done at a certain time and a certain place and under a certain care. So the registry is like an address where can I find a will under a person's name. So once it becomes the time to open a will, what are the documents that we need? First of all, we need a declaration of death, which is a medical document signed by a doctor declaring that this person born on that date, having this Medicare card number, has died at this place at this time under the care or not, whether it's at home, whether it's hospital, the residence, and for what were the causes of the death. So this declaration of death is necessary in order to either obtain a copy of the will if one doesn't have a copy of the will, either to question the registries, but through a will search. So if I do have a declaration of death, I may ask for a will search. I don't need a notary, I don't need a lawyer, but I can opt for having a notary or a lawyer to ask for the will search. The will search being done within the registry that we just saw, the registry of will at the Chambre des Notaires and the registry of will at the bar. So these, when a will search is asked, it takes a few days. It can take a few hours if it's done through lawyers and notaries. We have some sort of more or demand are treated faster. But if a will exists and we already know what the will contains, and we already know that the will has not been changed, and we already know that's the very last will, maybe we do not need a will search. In other words, there's no duty to obtain a will search. In my practice, I always verify that there is a will search done because I do not want to be in a position where I'm being questioned for not having the very last will. And usually fights and conflicts happen over the fact that the will was signed recently and was changed upon some pressure or coercion. But this is the litigious part. In a regular situation, copy of a will can be found to be the very last will, valid will, and can be used upon to make the necessary decisions further to the death. Once we've opened the will, once we know who is the liquidator or the legal executor, we also know that there are duties attached to the legal executor. We also know that the legal executor in the will or liquidator has many powers and has also duties. The main duty being to respect the directives in the will. And when would the execution of a will terminate? Well, upon the termination of the estate or distribution of all assets. Now let us see what forms the will may have. We have in Quebec 3 forms of wills. One done at the notary's office, which is the notarial deed. The fact that the will is notarized means that it's making it an authentic document. The authenticity of a will permits some quietness, permits some reassurance to its validity and its solidity. But it's not necessary, it's not obligatory. A will can be also valid if it is not notarized. A will done signed in front of 2 witnesses is also a valid form of will. In other words, it doesn't make it more valid if it's done with a notary. What is of importance if it's done in front of 2 witnesses is the condition of being signed in front of two witnesses. Witnesses who are not being that are capable to find the person able to sign, not necessarily being knowledgeable of the content of the will, but are able to confirm that the person signing the will was in fact capable to sign. Because one may not be under pressure or coercion to sign a will when the person is so fragile, so vulnerable. And by this, I mean emotionally, mentally fragile. I don't mean physically, I mean mentally. The third form is the holograph without a witness. I decide that tonight I want to sign a new will that is going to invalidate preceding will, that is revoking the other wills I've done before, and I have no witness, and I sign my will, and I have no witnesses whatsoever. This is also a valid sign. The only consequence of such is that the legatees and heirs will, in all probabilities, have to have this will homologated with a court to render it official. What will a will contain? Well, as I said earlier, disposition of the body and distribution of property. So one may think that upon one's death, wants to give for all of its organs, just one organ. Depends on each one's situation, each one's option, each one's beliefs. One may decide, yes, I would like to give my body to research. I think I don't need my body anymore. Maybe some institution, some university, some faculty might be interested, and there are possibilities for that, but it needs to be decided in advance because some arrangements and decisions and documents need to be signed prior to body donation for research. And also the ceremony, we are presumed to be able and free to decide what sort of ceremony we would like to have. One may decide, I'm going to leave it all to my heirs to decide. One may decide, here's what I want to be done upon the disposal of my body. I want this ceremony. I want this place. I want this music. So it's really up to us, to each one of us. And distribution of property, well, this is of a great importance, probably one of element that we refer to automatically when we think about wills. Do I name one liquidator? Do I name 2, 3 together? How many substitutes do I name? How to choose? If I have no one, how am I going to choose someone to be the liquidator? Some notaries accept to be liquidators. Some retired notaries, retired judges, retired lawyers accept also. It is at times, depending on the estate, it is a job. And it is why in the will, some will make sure that not only the fees of the liquidator will be reimbursed, fees like paying for the will search or paying for transportation for going to the bank or paying for copies of documents or paying for, yes, all sorts of important documentation. So these are fees. But maybe one is also considering to compensate the liquidator with a nominal sum, a few $1,000s, so that the liquidator, having spent that many hours on liquidation, is also compensated for his work. So the choice of a liquidator is really up to the author of the will. One thing is important is to ensure the replacement of liquidator. So if I name my wife or my husband as liquidator, I want to make sure that if my husband predeceases me, I have nominated a substitute. And if this substitute has predeceased my husband, who's predeceased me, then I want to make sure I have someone who will replace. It is important, but say there's no mention, say there's even no will at all. There's no replacement to the executor. The law provides with solutions. At any time, the law provides with solution. Because I may be with no husband, with no wife, with no children, with no family. And I don't know exactly how this will I'm going to prepare. I don't know if I want to give to Red Cross or not. I don't feel like giving to my very small cousin. I'm not too sure if, and yet, if I die before preparing or signing my will, the law provides with. The law always provides with the solution for the estate of a person who has passed away without a will. And but if we are preparing one, it's good to identify those substitutes. Legatees, I want to identify who they are, what is their name, what am I going to give to them, and when. If I want to give to my nephew a piano, maybe I want my nephew to receive this piano at his age of 30 years old and not right away. I may decide also in my will that I want to distribute my assets to all of my children equally. I may decide not to distribute to all of my children equally. I may decide that one child will have more because of some difficulties he's had in life, because of particular health condition. I may decide I may do a fiduciary will because I know this child of mine has real health problems and permanent health problems. I want this person, this child of mine, to be able to have access to this leg, this money I'm giving him, and that he be not penalized if he has other revenues from another source. So there are plenty of possibilities, and one has to consult at times to ensure that ultimately it will go smoothly at the time of opening the will. One may decide not to give to any children. If we have a situation at this moment where the mention is expressly made, I'm giving to Old Brewery Mission, I'm giving to Oratory because my children have had enough. I've given them all my life, and I've given them throughout my life, and I feel I want to give to some such faculties, such good mission. So that's one thing that may be thought of and maybe change at times and need not be for lifelong, but maybe signed today and still valid, and will be still valid up and until the will is changed. What I have written in my will is still valid up and until the will is open. So it can be 20 years from now, it can be 5 years from now, and if it hasn't been changed, it's going to be the last will, and it's going to be that will that will be executed. There's no péremption. How would you say that, Leila? Péremption. Expiration, right? There's no expiration. Expiration doesn't exist. It's replacement or revocation.
Expiry date.
Expiry date, thank you. I'm also including in my will that I want the executor to prepare an inventory. An inventory means what is the value I have at the time of our death. So because we all know things change, etc. So I may my investments may raise, may drop. So the inventory is really at the time of the death that it should be made. Sometimes we may exempt the executor to make an inventory, which is giving the liquidator less job than if an inventory needs to be prepared. Account means rendering account. Do you want to ensure that if you nominate one child liquidator, you want this liquidator to render account to the other children or not. At times it is useful to have an account to the others. At times it raises more questions than less. What is of interest here to say is that whatever you decide, maybe it's a good thing to, depending on each one's familial setting or situation, it may be of interest to inform the children, to be transparent, to put the cards on the table so that there's no surprise. I'm saying this because I'm a litigator and I see that a common denominator is miscommunication, presence of money, and concerns or questioning that are not answers, and bit of jealousy between one or the other. One is being named, the other is not named. It doesn't mean because you name them 3 liquidators that they will work easily, or that it will be better. It doesn't mean because you name one, it will work better. What is successful, I would say, is transparency and communication, and making sure everyone is on the same page with respecting your choices. That is of importance. And finally, the fees. Well, there's no, as I said, there is a possibility to invoke, to set up fees for the liquidator. So these are the elements I wanted to express to you with regards to the will. So maybe now that we've covered this topic briefly, I think it could be time to go with questions.
So while people look around their screen to raise their hand, I'm gonna go with 2 questions we received in the chat box while you were speaking. The first question is, under what situation can a will be contested?
Yes, there are a few situations. Most of the situations of contestation of will is really to do with, I should say, capacity of the author of the will to change the will at a certain time in his or her life. In other words, the main cases that we're bringing to court are where an heir, a family member, or one who would be entitled to receive by way of the will is not receiving what should be in his interest or her interest, what should be the maximum he should be receiving. The distribution is not to his or her satisfaction. So they contest by way of seeing that a will has been signed in a period where the person was not fully capable as it used to be before. In particular, those contesting raised the fact that the person was seen by a doctor and the doctor had questioned, and the person has seen some memory loss, some lack of judgment, and questions the capacity of the person to sign the will. We see it also when in cases where a family member learns a new will that he was never aware of, that was signed when the deceased was living with a family member, was brought to a notary unknown by the deceased, has signed a will that is not in the first language of the person, or a language that the person would know of, second language but that person would know of. These are the main situations where we see there is contestation. Does that answer, or is there additional
I think so,
questions?
because we receive a thank you upon your answer.
Good.
On the chat box. I've got 2 more questions. The second one is, once you assign a will as irrevocable, can it be revocable. You alluded to that when discussing the holograph will, but once it's assigned as irrevocable, can it be revocable?
Will is always revocable, except when one is not capable to revoke it. If I come to an advanced stage, let's put it a very clear case situation. If I come to a stage of semi-coma, I'm not capable to change it. So it will not be revocable. Insurance contracts may be irrevocable. I design a beneficiary irrevocably, but wills are not said to be irrevocable. If I sign a will saying it is irrevocable, it would be my choice. It would mean that I make a sound choice now, and I don't want my will to be revoked. So I'm binding myself not to revoke it. Is this possible? Haven't seen this yet, but I would say it is possible that I bind myself. I'm entitled to bind myself. And Paul, if you say you assign a will as irrevocable, well, when you sign a will, in front of two witnesses, this will may be revoked a year after, maybe revoked a month after. Maybe there's a new situation and you want to revoke it because, unfortunately, your niece has passed away. And you say, okay, I need to change it. I need to revoke and I need to make a new one. And you cannot just put on a piece of paper, put an attachment to your will and believe that this will is going to be valid, especially if it's done in front of two witnesses. Because the two witnesses were present when you signed, or the notary was present at your signature at a certain time and date. So if you change it, that person was not present. So you cannot just add some post-its and few changes. You have to ensure that any changes you're going to bring, maybe not by a way of a completely new will, maybe by a way of an addendum, you have to ensure that you also comply with the necessary guarantees of validity. Does that make sense?
So might as well go to a notary if you want to bring changes in part or in full to your will, I guess.
Yes, if you've done by way of if you have a notarized will, it's certainly much safer, much better to ensure that you're going to bring the change through the services of the notary. Mind you, in day-to-day life, and you've lived long enough, everyone, to have seen many, or possibly some situations. I've seen many cases, one of them being family members know that mother wanted to give that piece of her belongings to that particular child. And no one is contesting. It's not in the will, so it will go. So do we need to contest on this? No. Has she gone to the notary to change it? No, she did not. She did not take the time. She did not put in money into this. She's told everyone, and everyone is behaving with respect to her desires. So this is also, there's nothing illegal here. Everything is legal, and it's the idea is to respect the person's wishes. But if we want to ensure that our will is going to be opposed to anyone who would come around and question the fact that you've given your chalet to these children and not to the others, then you want this to be all set up in your will. And if need be, an addendum should be attached with a specific date, etc., signature, etc. Difference between lawyer and notary. Well, a lawyer will and notary will. Well, difference would be could be the cost, mind you. Notaries do prepare wills for some notaries for $250 to $300. the cost would be similar. A notary will, as I said, is going to be an act that is called authentic. How do we say this in English? It's difficult to oppose to such an act. It's in minutes, and it's difficult, although we have, well, when you are a lawyer, anything that can be contested. So we've had at times contested the wills signed in front of notaries, and they have been invalidated. Why? Because they were not done with the full capacity of the person, with the full consent of the person. But the notary has signed. The notary was probably not aware of all coercion and pressure on the person. So we do not blame the notary here. But for notaries, it's a challenge to ensure that the person has full capacity and full ability to make independent decision at the time of signature. So essentially, the notary will stand up in a more solid way than will done in the office of a lawyer. The difference will be one of cost, because usually lawyers will charge less because it's not notarized. So that's the main, I would say, the main difference in terms of cost. In terms of content, it can be the same. And in terms of lawyers will not be able to prepare these type of acts, but we can register the wills. We have a duty to keep the wills also available in our office and register them in the registries. So the difference is not very important.
There was another question here that may be of interest to many. In case of two citizenships, which law prevails?
Well, the law of Quebec prevails over citizens. In a will, we may write up that we want the will to be administered on a different law if we have property outside the country. But if there is anything to do with opening up a will in Quebec, in the country, it's the country's laws that apply. So that's the rule. Yeah. We have another question, I think, also, Danielle. We have one question. If I think one question was, if what happens if a couple, husband and wife, both pass away in a car accident together, and they have given to one another in their will, they have given to one another. So what happens? Well, the law provides with, if there's no substitute to executor, if there's no substitute to legatees and all that, the law provides with who will nominate a liquidator for these two different people who may have common property, who will be executor, how do we arrange for this? The law provides with the nomination of a liquidator with the majority of expressed desire of the heirs. So if I have 4 children and 3 of them are in favor of nominating the elder and the 4th one is in favor of nominating the 2nd one, well, it's going to be the majority. So we will have the liquidator will be nominated at majority of the heirs who are living. So, and how is it going to be distributed? At times, it needs to be decided by the court, but if possible, it's set up in the will that if my husband predeceases, if my wife predeceases, then this will go to her and that. But then again, if it's not provided with, the law will provide with. And it's going to be distributed among the children equally. That's the basic rule.
Are there any more questions related to the will? We received a few questions by email before today. Some of them were addressed. We just did answer one. Some pertain to the second part. And today, anyone else? So I don't see no one raising hand. No one is chatting. Another question. So I'll suggest we move on to the second part. If you've got some questions that arise pertaining to the will, you can still bring them forward when we get to the second Q&A period at the end of the section on the mandate and the power of attorney. So if everyone is good for it, let's move to the second part of our presentation today.
Yes, and we're on time, so we're all happy.
Right.
I don't hear you, and I hope you enjoy listening to this. And if not, please raise your hand or do something so that we can improve.
I will unmute everyone at once at the end. I just want to manage the Q&A period. If you want to ask a question, and I can unmute one at a time, but at the end, I'll unmute everyone.
Very good. All right, so power of attorney and protection mandate. So power of attorney is, as we said earlier, is a contract. So it means we need to have an agreement between two people. So if you sign a power of attorney, it means you are firstly a person of 18 years and over, and you are capable to sign. You understand what you're doing. And you want to express in writing that you want to have someone who will represent you in certain actions, in certain decisions, in certain acts. So as a person who is capable to decide, you still want to have somebody else who's going to also represent you as a capable person. It doesn't mean that you delegate irrevocably or for good. It doesn't mean that you are not capable to do it anymore. It means that you want to be represented by a person in a way to assist you, but it's more than assisting you, it's for representation. So this person may sign for you, they make decision for you. So it's an option. When do we find this option interesting? Probably when we want to have someone who is more available, interested, objectively interested into helping, objectively interested into the administration of your property, enabling you to decide and sign and make some acts that facilitate life. Juridical acts may be foreseen, such as writing checks, such as cashing checks, paying bills, such as talking over the phone and making arrangements for services, such as canceling a contract, such as contesting a raise in the lease, such as negotiating a lease. So there are multiple juridical acts. I may want to have someone to whom I delegate, and I have confidence into this person, and I feel that it's appropriate. So I'm still capable. There's no condition that I be incapable. There's no condition that I be hospitalized. There's no condition that I be with a physical deficiency or difficulty. No, there's no condition of execution. One needs to be only of 18 and over and capable to sign a power of attorney. Does it need to be in writing? Usually it is in writing. It's a legal document. Does it need to be signed in front of witness? No. Usually we do. Why? Because we think it's safer. Because we want it to be clear. We don't want no one to contest. Oh, he signed a power of attorney. Oh, how come? When was that? Who was there? Well, if I put a location, Montreal, that date, and this person, and I have a witness, it's probably more solid than just to write a power of attorney without a date and without with only my signature. Mind you, in litigation cases, we've had all sorts of things. And a power of attorney without the signature of the mandatory, the one who is receiving the power of representation, is not invalid. It is not invalid, but it's, as I said, more solid if the mandatory does sign. Does sign also that he accepts or she accepts to do the work of collecting the leases, collecting the rent, sorry, or going to the bank, or taking care of the cat, or doing the laundry or the whatever that needs to be done on a daily basis against contribution. It's safer. It's safer to write it, and it's safer to date, and it's safer to fix a certain time of performance, because I delegate to someone an authority over my say, over my decision. It's probably safer to fix it in time. Conservation, well, I should keep a copy. Can I make a power of attorney through an attorney? Through an attorney, through a notary? Yes. Do I need to? No, it does not less valid. But I may have a power of attorney that's been done at a notary's office, and the notary ought to keep it. Usually, I would like the mandatory to have a copy, and usually the mandatory would not be able to act if he doesn't have the power of attorney anyways. So he needs to keep a copy of it. May I modify it? May I revoke it? Anytime. Anytime I'm capable, I may decide August 6, 2020, that's it. I want to change it. I don't feel I have confidence in you anymore. I don't feel I should trust you anymore. You're not reporting to me enough. I don't see my bank account summaries. I need to see them. I don't have explanation upon my questioning. I want to modify. I should be able to do so without reprisals. I should be able to revoke and modify upon my own say. It's easy to say, but when it's easy to say in particular when you have not planning on having the support of the mandatory. When the mandatory is present and doesn't support the change, and I feel less strong to oppose, to have him step back with his pressure, it's more difficult. But that's why it's probably a good option to consult person in authority, legal authority, such as an attorney or a notary, to be supported in modification or revocation or preparation of a power of attorney. Registration, there is no obligatory registration. There is, in fact, no registry of power of attorneys. There is registry for wills, for protection mandate, but not for power of attorneys. In other words, you cannot search for powers of attorney. In other words, I see there's a mistake in it's written resignation instead of registration. Sorry about the typo. One cannot search, oh, mom has changed a power of attorney. Oh, I know she was brought in with my brother to the notary. I think she has changed her power of attorney. How can I be sure? The notary shall not say over the phone, because this is private information for one. Mother is not able to answer. Is it possible to know? Is it possible to question? No, no one may. Except if it's done at the bank institution. Some bank institutions do not keep secret the information and do inform a family member that the power of attorney was changed. This occurs pretty frequently. And therefore, the one who had a power of attorney before and is being told that the power of attorney was changed, then may be informed by the bank institution if questioned by the family member. That brings issues of litigation at times, I can tell you. So copy of a power of attorney shall be in possession of the author and shall also be in possession of the mandatory. So in your power of attorney, you would set up the different powers. Okay, for that period of time, for these 2 months or for this year, you will bring to me the bank summaries and explain to me what you have done in terms of transactions. This I want to see every first Sunday of the month. I want to know just explain this to me. We'll have a nice coffee together, and then I want to know about this. I want you to ensure that you're going to be giving to your brother who has health problems every month $250. Some of you may have power of attorneys. Some of you certainly think it's a valid tool. It's certainly a valid tool, especially when we are still capable of thinking, making decisions, knowing what we want, and expressing our wishes, but probably in need of some assistance. And it's interesting also to have someone else who's going to get involved and helping out in the outcome of certain acts, but not yet incapable. This power of attorney does bring some confidence into actions that need to be done. I'm not talking about tax declarations, but this is one element that is of great interest, to have a power of attorney, so the mandatory may prepare the tax declarations, discuss with the accountant, etc. So when does the power of attorney ends? At the death of the mandatory, at the death of the person giving the power of attorney, at the homologation of the mandate, upon revocation, or upon the institution of tutorship. In other words, the power of attorney is valid up and until I'm capable. When it comes to the point that I'm not capable anymore, and that there is institution of some protection by way of tutorship or homologation of the mandate, then the power of attorney is set aside. But up and until this point, the power of attorney is considered to be valid. That's the law. Of course, if I have a power of attorney and I pass and I die, or I revoke it, then the power of attorney is not valid anymore. It cannot be opposed anymore. So what do I put in my power of attorney? All issues pertaining to administration. The transactions in the bank account, the tax declarations, the investments, what I want this to be transferred or not transferred, the administration of my properties. The choice is mine, can be supported or explained or supported by an accountant, a notary that will suggest some options, some issues that could be put into power of attorney. But it can be as simple as the one you decide at home with your wife or husband. This we're going to give to this son to help us with this, this, and that, with the condition that he reports, for example, monthly to us where he is with the administration of what we have given him as a delegation of powers. And again, in the power of attorney, I may include substitutes. And I may include, as I said, rendering account, fees, and specify the duration, year 2020, or between this period and that period, or for the coming 2 months. So the power of attorney is a very good, a very interesting tool once well used. And the protection mandate is another tool, is another legal document that one could think of. Again, it's not an obligation, it's not a duty. No one is going to sue you because you do not have a protection mandate. It is very specific because it is a legal document that is meant for in anticipation of incapacity. While we all know that we are all going to die one day, no one here can say that we're going to be incapable one day. That I'm not able to walk or run as I used to do when I was 30 years old, that makes sense. Especially when I run up to 80, which is a good score. But one can say that I'm not going to be capable to make some decisions and all my decisions myself. There is a possibility. We all know that we can run into, and especially with the diagnosis of Parkinson, we can think, oh yes, the capacities will diminish, and maybe they will affect my judgment, maybe. But am I going to be declared incapable one day? Maybe yes, maybe not. So it's a useful tool that permits me to decide in advance if I become incapable to administer, to make decisions. Who would I nominate? Who would take the decisions in my place? Who would be able to protect me? Because the protection mandate is really to protect the person. The will is not to protect the person. The will is to distribute. It's not to protect the property, it's to distribute. The protection mandate is meant to protect the incapable person, to represent that person in the sole interest of that person, not anyone else, not to accommodate the family, but everything shall be decided, and that's very important. The courts repeat this. That's what we do. Even if I represent a family member, I'm always concerned with what is the interest of your mom or your dad here? Are you really acting in terms of representing, are all your acts of representation really in the interest of your mother or your father? And this is of immense importance, and it's written in the law, and it's where all decisions shall be oriented the interest of the person for all types of decisions. So compared to the power of attorney, which is essentially for administration, here we are dealing with all types of decisions, not only property, but also the person. So it involves many different legal decisions, and we will see them a little bit closer. There are conditions to this. There are conditions to using a protection mandate. Two conditions. The first one being the evaluations concluding to incapacity. Evaluations concluding to incapacity to make decisions. And the second one being homologation. One day when I die, someone is going to open the drawer and take my will. No way, that's for sure one day it will happen. But maybe in my drawer, I also have my protection mandate. And maybe it will stay in my drawer all my life, because I will not be subject to evaluations. I will be capable all my life, although I may be diminished, although I may be less vigorous, but maybe the mandate will never be used. In fact, protection mandate is a special tool we have in Quebec. It's been legalized in 1990. You don't find it in every province in Canada. It can be kept by the author of the mandate, by the notary, and by the person named in the mandate, which is a good option because you want this mandatory to keep a copy of the mandate. I may, like for the will, I may modify it, I may revoke it anytime. There's no obligation to change it. There's no obligation to revoke it if the situation has changed. I may have substitute, I may have set up alternatives. If this doesn't work, this is going to work. But I may opt for changing it completely. And we will see the forms. The other interest in the protection mandate is that I may register the mandate into a specific registry called the mandate registry, which is a registry different than the will registry. In fact, we have many registries in Quebec. We also have a registry of organ donations. What does it mean that there is a mandate registry? It means that I can question the registry to know if there was one day a protection mandate registered under the name of a person. What does it take to have the mandate used and executed? It takes homologation. Homologation means rendering the mandate able to be executed. to have all of its powers. So we need a judgment. Whether I knock at the door of a notary or knock at the door of a lawyer, ultimately there will be a judgment homologating the mandate. In other words, it's not because the mandate was done with the notary's office that it's more valid and that it has full powers. Even if it's done with the notary, I will need to have the mandate homologated to have the possibility to execute it. So there are steps for the protection mandate. Before going to court and asking for homologation, the very preliminary step is to see if we are in a situation of incapacity. And incapacity is one notion that is of great importance to be comfortable with. We saw that we needed evaluations and homologation. Evaluations are done by two people, different people, a doctor and a social worker, who both have to examine and evaluate the situation and determine if there is a diagnosis and if there is a history supporting a conclusion of incapacity. Because you know as much as I know, and we all know, that illness does not equate to incapacity. It's not because I have a diagnosis that I am incapable, not at all. There is a need for more than that. A diagnosis is not the person. The diagnosis is just one stamp here. But this, whether it's deficiency, whether it's, and the text you read here is really the text that's in the law, that is applied by all courts. To conclude to incapacity, there needs to be either an illness or a deficiency or a debility due to age. So as we all know, getting closer to 100 years old is making us more fragile to debility due to age that will impair my capacity, whether it's my physical ability, whether it's my mental faculties. But there is a need to be evaluated. And being more fragile, being isolated, doesn't equate to incapacity. Having diagnosed Parkinson doesn't equate to incapacity. There is a process there that needs to be evaluated to decide if there is a conclusion of such. The way doctors do it is they go over certain issues, such as those enumerated here. Does a person know where she lives? Does she know what time of the year we are? Does she know that it's better not to put a raincoat if it's her family members' names? Can she express emotions or no emotions at all? Can she communicate? So these are elements that are evaluated in order to determine if there is a loss of abilities and to determine if there is a conclusion of incapacity. So once this has been evaluated, then the reports are prepared. If the conclusion of incapacity for both evaluation, then we may have reports. Then one may ask for a copy of the mandate, and one may apply with a valid mandate, apply for homologation with enhanced the two evaluations of incapacity. The protection mandate will contain powers and duties imposed on the mandatory, and we will see what is the content of the mandate in a few minutes. What puts an end to the protection mandate? It's the death of the mandatory. The person who has signed the mandate is the mandatory, and upon the death of the mandatory, of the signatory of the mandate, then what comes into play? The will. So once the power of attorney is invalidated by the protection mandate because we homologate the protection mandate, then after the protection mandate would come into play, if it if we have come through this situation of incapacity. And once the author of the protection mandate dies, then the will comes into play. And the mandatory doesn't have powers, while the executor of the will has powers. And the executor of the will doesn't have power, while the mandatory and the protection mandate has power. At times it can be the same person, obviously, but it's just to say that there are different steps whereby, therefore, we are respected with our decision in our legal documents. Forms of protection mandate can be in front of a notary. Notaries prepare those, and they are authentic documents. Can be opposed to others. They're valid documents. They are documents that usually a notary will propose to you. Oh, do you want a power of attorney? You want a will? Would you like a protection mandate in addition to your option? How much does it cost? It varies depending on the content and depending on the notary, and depending if you sign more than one legal document. It varies a lot. You have to inform yourself. The other valid form of protection mandate is the one signed in front of two witnesses. So those are the two forms. And if I sign my protection mandate in front of two witnesses, it doesn't mean that I will show my witnesses the content of my protection mandate. It's only that I need to sign in front of them. They have to sign both in front of one another, and they have to date, and they have to be comfortable with the fact that I'm capable to sign. Because if I'm not capable to sign, they shall say, no, I'm not going to sign because you don't seem to be fit to sign your protection mandate today. So this is the form we have in Quebec. And the witnesses shall not be named in the protection mandate. So they cannot be my mandataries. They cannot be beneficiaries, or they cannot have an interest into the mandate. In other words, it could be what we do here in my office. We have my secretary signs and one other lawyer signs, and therefore they're witnesses. You have no interest whatsoever. You can go to the bank, they can be witnesses. You can have your neighbors, they can be witnesses. So these people who are not, have no interest into the mandate, and they need not see the content of the mandate. And what does that mandate contains? Well, contains all of this that we have already seen with the other legal documents in terms of administration of property, transactions, tax declarations. So you can leave it all the important decision that one would make when being capable is all delegated to the mandatory. These are very important decisions. Why? Because it's the mandatory is like going to be in the shoes, in your shoes, and is under duty to act in good faith as a good father, not a godfather, like a good father, like a reasonable person who's going to take care as if it was for himself, but more than that, as if it was a parent. So we comply the mandatory to act as a reasonable person, like a parent. The same principle applies for issues related to the person. You see the difference with the power of attorney? The protection mandate gives the possibility to determine who's going to decide once I'm not capable anymore and there's a necessity to homologate the mandate, who's going to decide for health services at home, health services outside home, lodging, end-of-life decisions. You put into the hands of a third person the decisions that are going to be taken. It's easy when you are married and you have full confidence, but if you're single in life and you don't have no one to refer to, you try to think, okay, I'm like this. My neighbor, I have seen very nice situations in my practice. One involved a tenant. The landlord was certainly 30, 40 years older, and he had been his tenant for 30 years. And he was so proud that she would have him as his representative. He was representing her. He would go to the hospital with her. He would help her out with her diminished capacities. And she had full confidence, and he would honor her confidence. So he was part all the way through for all these decisions, to be administrative or regarding her person. She would oppose to medication, and he would say, oh, maybe it's better that you will take, let's go and let's see if it's possible. So she, what it means when I'm saying this, I mean that the choice of a person who is going to be named in a protection mandate is at times difficult. It's impossible if I have no one in life in whom I have confidence. It would not be possible. So a protection mandate may not be possible for me if I have no one I would identify. But the choice of the person is, it's a person with whom you are comfortable, that you have confidence in, and that is going to be, maybe for a period of time, able to act as a representative. No one is there for irrevocably, so you want to have someone else. So you want to have substitutes. And maybe if you nominate your husband is not capable anymore because he already has some difficulties and it's too much of a job. It's too much of a duty. So you make sure to put in substitutes. How many substitutes? As many. How many mandatories? As many as you wish. It's not because you put more that the solution will be easier, the decisions will be easier taken. No. But it's not that if you put just one, it's going to be easier. Not necessarily. Maybe that one is not in a position anymore. Maybe that child is away or has so much work or so much difficulties already with her own marriage. So if I'm named mandatory, I'm not obliged to accept. If I'm not capable to do the job, quote unquote, then I may say I need to be replaced. So in the protection mandate, it's nice to have a substitute or other alternative that you give to the person you name the option to choose a replacer, to choose a substitute. So you nominate your daughter, but you say, okay, if you're not able to, I have full confidence you can do it. Say you're not able to. I leave it to your choice to decide who would replace you. Maybe it's at the point that she thinks her daughter could do it. And her daughter is only 28, but she's very good because she knows grandma, because she knows ma's not in a position to do it. So it's the protection mandate is a nice tool, and one needs to know how to use it for the best outcome, if I could say. And again, in the protection mandate, I may ask for accounting. It means I name you mandatory, you report to your sister, your brother. I name you mandatory, you report to your children, because I have confidence in you, but I would like you to be supported also by those who will receive an account. And you may think about fees for the mandatory. So in conclusion, because I think it's about time, we are on time, I think, Daniel. So in conclusion, let me summarize this. Wishes that are expressed in a protection mandate do not constitute advanced medical directives. You've heard about advanced medical directives. You know that you are able to sign those, prepare those. Again, you could go to a notary, but again, there is also an easier way, with no cost, with RAMQ. So, but the protection mandate is in case of incapacity, while advanced medical directives is meant for case of incapacity, but within specific, very specific situations. We're not dealing with advanced medical directives today. we may one day, if you feel you want to have more information on this particular issue. But protection mandates are useful to know your wishes in case of incapacity, while a power of attorney is maintained valid until it is replaced. And it will be replaced if it's necessary only, and if there is institution of a regime of protection, whether it's homologation of the mandate or tutorship. So in conclusion, you may express choices in advance. You should be able that your wishes be respected. From the time you're not able anymore to express your wishes, you may so therefore decide in advance who would protect you in case of incapacity and how you want the distribution of your assets and the decisions regarding your body be respected at the time of your death with your will. So all of these legal documents are open to you, and they can be useful, and they coexist as legal documents. So I hope I have covered the topics with you, but I think we may have questions, and if so, we will be glad to take them.